Please, dear colleagues, dear friends, take a seat quickly. We have to continue with the next session. PowerPoint, il y a peu de choses, il va peut-être parler moins que...
C'est plutôt économe. Hein,
oui, oui, je pense. Hein, parce qu'on avait prévu dans le programme pour lui 20 minutes. Dans le programme pour lui 20 minutes. So let's continue with the next panel on artificial intelligence. But let me just warn you that after the end of this conference at 1 o'clock, we all have to leave the room because there is a next activity here and they have to reorganize the room. So please don't stay inside the room to speak and continue to do that outside. Now, I give the floor to Mrs. Anna Buchta from the European Data Protection Supervisor, who is going to chair the next panel. I hope that all the speakers will understand that we really have to respect the timing and so the time allocated to their intervention, because otherwise the risk is that we will take no questions, because we will really have to give the floor to Henrik Nielsen, who will conclude the day at 12:45.
Thank you very much, and good morning, everyone. So this is the last panel of the conference, and the previous discussion already ventured a little bit towards discussing the impacts or the use of technologies and the challenges that brings to this area of freedom, security, and justice. But in fact, the technology imprint or presence is much bigger than that. As you know, there has been a large and growing number of large-scale IT systems that exist already, such as the Schengen information system, the VIS, the Eurodac, but there are also new systems that are being built, for example, ETIAS and also the entry-exit systems. They are or will all be processing vast amounts of personal data, often of very sensitive nature, such as biometric data, and they will exist in very complex and evolving legal environment. So this panel is an invitation to consider both the present but also the future. So to consider the functioning of technology and those large-scale systems in light of new developments that are likely to exacerbate existing challenges as well as create new ones. And this is in particular the implementation of the interoperability framework, but also the increasing potential use or effects of artificial intelligence. So to have a beginning of a discussion, which I'm sure would merit its own conference, let me introduce our speakers. First of all, Professor Niovi Vavoula, Senior Lecturer and Associate Professor from Queen Mary University of London, and an expert in immigration law, EU criminal law, privacy law, but also one of the leading experts who are helping us all understand and navigate this new landscape where technology and law have to coexist. Finally, second, I hope he is already with us or will be shortly. We will have Luca Tagliaretti.
I'm here.
Just on cue. Good morning.
Good morning. Good morning.
Luca is the Deputy Executive Director of EU LISA. As you know, this is the EU agency for large-scale IT systems, and Luca is joining us online from Tallinn. And last but not least, another person who sits in the center of the implementation of the new framework, Marc Sulon, head of unit from the Director General Migration and Home Affairs, responsible for implementation of interoperability. Without further ado, I give the floor to Niovi for the presentation.
Thank you so much, Anna. First of all, thank you very much for giving me the opportunity to present at this highly timely conference. My presentation is going to look into the potential use of artificial intelligence in interoperable large-scale IT systems for third country nationals. And I mentioned the potential because what I would like to show in this presentation is that there are stuff that we do know about the use of AI in large-scale IT systems, but there is also a series of gray areas that I would like to point out and perhaps seek clarification. And then, in line with the explanatory blurb for this panel, I would like to demonstrate what are the opportunities for governing interoperable and potentially AI-reliant large-scale IT systems, but what are the potential loopholes also in this regulation of the systems. And in that regard, I want to focus on their evaluation, looking into the Schengen evaluation and monitoring mechanism, their supervision by national data protection authorities and the EDPS, and also the exclusion of large-scale IT systems from the proposed AI Act, and look specifically on Article 83, which excludes the skill systems. In looking on these three topics, I would like you to remind you that a human-centric artificial intelligence must carry specific characteristics, and that comes from the communication by the European Commission from 2009 on building trust in artificial intelligence. So human-centric AI requires human agency and oversight, so obviously supervision is really important in that regard, technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, societal and environmental well-being, and accountability. And again, all the three aspects that I will talk about, we touch some upon on some of these elements on human-centric AI, and I will conclude by saying that at least at this point, with the gaps that I will explain, we seem to have a quite defective human-centric AI in the use in migration, asylum, and border management. So I think that the large-scale IT systems do not need further introduction. There are three currently operational, three under development. But what is particularly interesting is how these interoperable systems are going to potentially use AI in their development or in their future at a later stage. So in that regard, I want to erase 4 points. The first one is a little bit less problematic in the sense that, as Anna mentioned in the introduction, with the exception of ETIAS, all large-scale IT systems will process biometric data, fingerprints, and facial images. And it is, the legislation points to the direction that facial recognition technology will be employed for identification of third country nationals, particularly on border crossing points or on national territory. I highlight in green the case of SIS because it is a little bit more interesting than the others in that the legislation mentions that it will be up to the Commission in a delegated act to define other circumstances in which fingerprints and facial images could be used apart from identification in border crossing points, which creates a lot of issues as to what are these circumstances, why should the Commission determine that in a delegated act, and therefore this is a particularly interesting case of potential use of facial recognition in an unknown way. The second, and perhaps the most obscure potential use of AI in interoperable IT systems will be in the context of algorithmic risk assessments in the cases of ETIAS and the visa information system. So these systems currently, one is under development, the other one is under refurbishment, will essentially use algorithms in order to allow to determine whether a visa applicant or a travel authorization applicant may pose a risk to regular immigration, public health, or security. And these algorithms are made called screening rules in ETIAS, specific risk indicators in the case of this. We know that there are algorithms. This is in the legislation. We do not know the extent to which they will employ artificial intelligence. And this has been a particularly gray area in the literature with no specific information as to whether this is going to be based on machine learning already from the beginning of the operations, or at a later stage there will be machine learning in order, for instance, to triage applications on visas or travel authorizations. The third aspect that I would like to talk about in that regard is how essentially interoperability is a prerequisite and a facilitator for the use of artificial intelligence. The case of the SER biometric matching service is very straightforward. Facial recognition will be helped by one of the interoperability components, which will store all the biometric data of third country nationals stored in the underlying systems. But also something that has been evading legal scholarship is the role of the Common Repository for Reporting and Statistics, which is essentially a big database with non-personal data, at least in principle, that will enable the compilation of tailor-made statistical data that will for sure be then used in order to determine the algorithm for the screening rules that I mentioned earlier. So this is something that is quite interesting, and we see how interoperability essentially helps in the operationalization of artificial intelligence for large-scale IT systems. The last thing in that regard has to do with a potential future use of AI in the context of detection of forged travel documents. This is not foreseen in the legislation. This is my hunch. Maybe I'm just giving ideas for the future. But there is the three operational systems will store the copies of travel documents. And there are discussions, at least at EU LISA level, for the potential use of AI in detecting forged travel documents. So how to regulate these murky waters of AI in large-scale IT systems? And the first aspect that I want to talk about has to do with the evaluation of interoperable IT systems. So the Schengen evaluation monitoring mechanism regulation enables evaluations to cover large-scale information systems supporting the application of the Schengen acquis, which is all fine. And in the previous cycle, we know that SIS and VIS have been subject to evaluation. The problem is that not all systems are part of the Schengen acquis. The SIS, VIS, ETIAS, and the entry exit system are part of the Schengen acquis, but Eurodac and ECRIS-TCN are not. So in the interoperable environment where data are going to be stored all together in different systems collectively, it becomes impossible to evaluate the operation of interoperability when some of the systems are not part of Schengen. So my questions in that regard have to do with how to evaluate interoperable IT systems when some of these do not fall within the scope of the Schengen evaluation and monitoring mechanism, when how to evaluate the systems which fall within different policy fields of the Schengen evaluation and monitoring mechanism. For instance, VIS is part of the visa policy. SIS is a standalone policy field. Data protection is a cross-cutting policy field. And third, how to evaluate interoperable IT systems when some of these policy fields are less advanced in the evaluation than others. And this comes from a study from 2020 for the European Parliament, which showed that the areas on visas and data protection were less developed than others. So my suggestion in that regard would be that there is a need for a holistic approach to the Schengen evaluation and monitoring mechanism in respect of large-scale IT systems, with meaningful evaluations that go in depth into the operation of interoperable databases. And already we have the fragmentation because Eurodac is not part of the same. And so to the best of my understanding and my research, I've never seen any evaluation of Eurodac ever. It's only been some evaluating parts with regard to Dublin regulation. The second aspect has to do with supervision of large-scale IT systems. So supervision currently takes place by national data protection authorities in respect of the uses by member states and by the EDPS in respect of the use of the databases by agencies such as Europol and Frontex and, of course, EULISA. There is also a coordinating supervision committee, which has been established under the auspices of the European Data Protection Board in order to coordinate all the different authorities towards supervision. So I won't touch upon the many challenges that supervising interoperability will pose, how the many logs of the data protection activities will make it impossible to supervise the systems, how we have too many actors with quite different roles under data protection law. I just want to focus on one particular point, which has to do with the potential use of AI, which brings to the fore the fact that because AI does not only pose data protection concerns, but pose primarily non-discrimination concerns, but also concerns in respect of other fundamental rights, we have a problem with supervision because IT systems have primarily been dealt as a technical data protection related challenge. And therefore, with artificial intelligence and other fundamental right challenges will come at play, which will not be for data protection authorities to supervise as they currently stand. So we need a holistic approach here as well, which will take into account that AI concerns process challenges to other fundamental rights, non-discrimination, right to good administration, rights of the child, right to an effective remedy. And supervision should not be just about compliance with data protection law, but should be a more holistic supervision on different fundamental rights challenges. And in that regard, my suggestion would be that we need a supervision which is targeted at national level with specialized units precisely on large-scale IT systems, with trained officials not only on data protection, but also on fundamental rights more broadly, and supervision becoming an ongoing process that doesn't take place only every few years, because this is impossible to supervise with such a large scale of data being processed, and a process of supervision that takes place on the ground, in consulates, at the borders, on national territory. Finally, I wanted to talk about the proposed AI Act and the curious case of Article 83. So with this gray area of whether and to what extent AI will be used in respect of large-scale IT systems, it is quite interesting that the AI Act gives us a hint that actually AI is going to be deployed in relation to large-scale IT systems. Because if it wouldn't have, then why Article 83 excludes databases from the scope of the AI Act? This is an implicit recognition, one might say. So the AI Act, I'm not going to talk about it too much because it has a lot of aspects on AI and migration. I just want to talk about databases. It recognizes vulnerability of migrants and refugees, and it makes a lot of, it considers a lot of AI systems as high risk, such as biometric identification. So facial recognition would fall under that, and algorithmic risk assessments, again, a high risk system. Yet it excludes databases from its scope. It says so, however, that if there is a replacement or amendment of those legal acts, which leads to a significant change in the design or intended purpose of the AI system, then the databases will fall within the scope of the AI Act. So why this exclusion? I've been struggling with this question for more than 2 years. The official answer is that we need legal certainty. I'm not sure I understand this argument personally. My hunch, and maybe I'm a little bit provocative in that regard, is that this is, it creates a divide between what EU can do in respect of AI and systems and what the member states can do. What standards should be applied by member states and what standards should be applied by the EU, and saying that EU legislature is beyond reproach. Maybe it's also an implicit recognition that EU systems are going to be discriminatory. They are not going to be able to comply with the AI Act, and therefore let's get them out of the scope of the AI Act. And also we have a problem with what a significant change would be in order to bring the systems within the scope of the AI Act. Hopefully, a campaign to which I have been fortunate enough to participate has actually been fruitful in that regard, in the sense that the European Parliament addressed this issue by bringing the systems within the scope of the AI Act and actually requiring, within 4 years of implementation, compliance with the requirements, which, as I said, for high-risk systems would require specific oversight mechanism, a lot of more transparency. So a lot of the stuff that we are struggling already would have to be rectified since if the AI Act, if Article 83 is abolished. The trialogue starts on the 23rd of July. I'm really curious about what will happen in that regard. I really hope that here, Marc Sulon is here. I'm making a call. Please don't block this amendment. I think it's very important that large-scale IT systems are going to be treated in the same way as national systems. But we will see what happens in that regard. So, to conclude, I'll try to demonstrate that irrespective of the fundamental rights challenges, we also have governance, regulatory challenges in the operationalization of AI interoperable large-scale IT systems. We don't have enough transparency and clarity as to what's happening on the ground. Maybe EU-LISA can help us understand what is being implemented and to what extent we have machine learning or AI more broadly. And this makes me led to thinking that we still have a quite defective human-centric approach in this particular field, which correlates very well with what is the position of a third country national at EU level, which is by default weaker. The EDPS has said that it seems that there are no data protection privacy rights of third country nationals at the border. And yes, data protection is vital, but in the era of AI, we have also other fundamental rights at stake. And data protection cannot resolve everything. So we need a broader conceptualization. Maybe bring national commissions for human rights as part of the evaluation of the supervision of the systems. And this opacity is may be rectified. We see EU-LISA keeping an eye on the developments on what is happening. We know that EU-LISA, for instance, is looking into detection of forged documents that I mentioned earlier, automated pre-processing of long stay and resident permit application, and trying to use AI to identify traveling patterns. So we have some clarity, but ultimately we do not know what the end game is. And I've been following databases for more than 10 years now. So I'm still trying to fill that puzzle of database. So thank you very much for your attention. I look forward to your comments.
Thank you, Niovi, and thank you also for being so disciplined and short in terms of time. That gives us a little bit of margin for the follow-up of the discussion. You have already made references to some points that our next speakers will for sure want to react to. So I would first invite Luca, if we can have the...
Thank you, Anna. Can you hear me, first of all?
We can hear you. We can't see you for now. So, oh, voila. There you are.
Very good.
So please,
thank you.
The floor is yours.
Thanks. First of all, I want to apologize for not being there in presence today. I've been following with a lot of attention also the panel this morning, very interesting. So I'm sorry I'm not there to engage with you directly. I think before talking about the systems and the role of AI, we should congratulate ourselves. I think the work that the Parliament has done, the Commission and the Council with this drafting of the new AI Act is very important, is an example of what the European Union can do to lead in the world in creating new legislation which also respect fundamental human rights and keep the speed with technology. So it's really important. The new AI Act, of course, is affecting EU-LISA, and we're keeping an eye on the debate ongoing, and we'll keep an eye on the co-legislator discussion starting in July. The agency, Niovi already mentioned, is developing and is managing a set of large-scale IT systems for border and migration management, law enforcement, asylum, and also recently by the EDR of justice. Just to give you an example, the systems are, for their nature, they contain a large amount of data and a large amount of personal data. The Schengen information system at the moment has more than 85 million alerts, 6 million only on people, and a lot of these alerts also contain biometric data. The VIS has more than 52 million visa applications, all with fingerprint set and biographic data. The ETS, the Eurodac for migration and asylum seeker has 6.5 million of fingerprint set. So to make sure that the systems are effective and are working properly, and considering the amount of data, we need to have the necessary technology to make the matching, the necessary technology to do the search on this large amount of information. At the moment, they are all separated. They are being created with different regulation. They have their own individual server space. They work as independent entities. They have their own data in sealed environment. They have their own biometric recognition and matching system, and there is no link possible between systems. But as Niovi already mentioned, the challenge will come with the introduction of VS and then the remaining element of the interoperability architecture. The interoperability architecture will allow this cross-matching, even though the system will remain logically separated. So data will be in their own systems. They will be subject to their own regulation, particularly in terms of search and access right, but there will be the possibility to provide a match of the templates of the biometric information. And this is at the core of the interoperability architecture. Without this matching, the boost that comes with collecting information will not be there. And so this is why, for us, it's important from the beginning to understand what is the best technology that we could use to ensure this matching. The use of artificial intelligence at the moment is, or the use of automation, let's say, is restricted to the SBMS and to the ATS, as it was mentioned. On the SBMS, the technology is doing a matching and of the biometric template, and is doing a comparison. This is necessary to provide a match, which is then given to the provide accuracy and will be used by the law enforcement or the border guard at the port of entry. It's essential. This is mainly done at the ES, so mainly done at the airport, at the seaport or land border, and it's necessary to be performed very quickly to ensure that we don't have backlog at the border, to ensure that we also have a reliable matching. So this is why it's important that we use the technology that are available to the maximum possible extent, and we can come back later on how we ensure that. With regard to ATS, there is a specific article in the regulation, the Article 33, which foresee the use of the algorithm for screening rules. This is used to analyze the application and matching the data contained in the application against a number of risk indicators, which are already being included in the system and are coming from previously identified security risk or even epidemic risk. So the case of, for example, of the COVID. If the algorithm will give a hit, if the algorithm suggests there is a further check necessary, the final decision is not automated. And this I want to go back to one of the questions in the presentation before. There is a human decision. So the algorithm will only indicate to the operator the possibility of a match. The operator will, at the national ATS unit, will make a final assessment. The assessment need to be manual, need to be done by the human, because there is the possibility of appeal. Applicants will have the right to appeal the decision, and to do that, they will have to do against an entity, an organization, in this case, the ATS central unit, who is doing this assessment. So it's not a black box. We have done a number of tests during the course of the year to verify how efficient this this deep learning technology is working, and we have done through feasibility study, also in the use of AI on the central repository and statistic, as it was identified before. In conclusion, the use of AI, or in general, the use of automation for us is essential to ensure the functioning of our systems. And this is true today, is relevant today, and will be more and more relevant in the future as the amount of data will increase, as the amount of system connected to the interoperability architecture will probably also increase. It's necessary that we have the tool that allows the system to work efficiently. We fully understand and support legislation to protect fundamental rights. We 100% behind that. We believe also the freedom of movements and the freedom of security are important rights. They need to be protected, as well as the freedom of having our border protected. So the question for us is not really to balance between fundamental right and innovation, but being able to embrace the innovation that comes, and with the objective of having in mind the protection of our citizens and the protection of the fundamental rights of all the European also travelers. So I think this, I would say, I would close here. We can go elaborate more on some of the questions that the Niovi placed before, but it's very interesting. Thank you.
Thank you very much, Luca. I apologize, the connection was not perfect at all times, but I hope we have not lost too much of your presentation.
I could hear you very well, but I'm sorry you couldn't. Sorry for that.
But you will stay with us, obviously, for the rest of the discussion, and there will be opportunity to clarify maybe if there are any questions. But before that, I would like to give the floor to Marc for the perspective from the Commission.
Thank you, Anna. Thank you for giving me the floor today. Good afternoon to everyone. I will try to focus on three elements. The first one, what we are currently implementing. The second one, concerning a study on artificial intelligence use that we performed 3 years ago in 2020. And finally, the proposed Artificial Intelligence Act, for which we have probably some answer to the questions that were put on the table by Niovi. So, as already indicated by Luca, we are implementing large-scale IT systems and their interoperability. The entry-exit system, ETIAS, the ECRIS-TCN, which is a justice area system. The future of this recast. We have already implemented the recast of the Schengen information system, and we are implementing in parallel the interoperability regulation. All these systems have clear establishing regulations, which are none of them referring to artificial intelligence. There are references to processes, to data to be used, to a series of data sets to be considered, but nowhere there is reference to artificial intelligence. In the same way, there is no reference to the fact that artificial intelligence should not be used. And here probably we have some room for interpretation about what we are calling artificial intelligence, if there is any intelligence in this, because at the end of the day, what we will do, things that some as artificial intelligence, but there is a debate around this. Automation of processes, multiplication of processes, analysis of a data set to determine, to find relations between elements, correlations between elements, statistics and probability. It's part of the work that will be done, and it's probably also part of artificial intelligence. So, as said, no specific reference to artificial intelligence, but to tasks relying on statistics. There is also a clear element of limitations that we have in these regulations. It's the fact that we cannot use statistics statistical report across systems. Currently, the legislation is limiting the use of data system by system, except for the relations between the entry-exit system and ETIAS, and between the entry-exit system and the visa information system, which are considering the definition of specific risks and could be used for also establishing screening rules. Here, once again, I would like to point out on a series of provisions that are limiting the possibility and controlling the possibility to have this kind of screening rules, is the fact that we have a clear indication that there is a control, not only the standard controls that we have in most of the system, but here we have created a specific control, which is called the Fundamental Right Guidance Board. That will assist the ETIAS central unit, which is in charge of implementing these screening rules. And this Fundamental Right Guidance Board is composed of, among other, EDPS representative of national authorities in charge of data protection. So it's something that we consider that is a guarantee concerning the use of these screening rules and the definition of these screening rules. It's coming in addition of a board which will be in charge of testing and validating these screening rules, but they will have to consult the Fundamental Rights Guidance Board. So we have provisions, and we clearly see that the co-legislator here has identified a potential risk and has taken specific measures, adopted specific measures for this. We have probably, it's clear, it was mentioned by Luca also, we have probably already artificial intelligence used in the biometric matching systems or services. It's clear to a certain extent that it's behind these processes, but for the rest, there is no certainty that it will be implemented, that it's necessary, that it's something that will be clearly used for different purposes. It's at least not mandatory according to the regulations. Even if we would be using artificial intelligence, we have also a series of provisions in all these systems indicating that in agreement with GDPR, there is no possibility for an automated negative decision affecting any human being. The only possibility that we have, it's a positive decision. If there is a doubt, if it's not possible to take a positive decision, and it's important the way it's formulated, if it's not possible to take a positive decision, if there is a doubt, then the process is interrupted and sent to a human being for decision. It's not indicating to the human being, look, you should take a negative decision. No, it's indicating this will be used to indicate you should control this, you should control that, and after this, you take the appropriate decision, and it's a human being taking the decision. Once again, with all the provisions of safeguards, giving the possibility to access data, to launch appeal procedures, and I guarantee you that implementing these provisions, it's a huge work because we have to publish for all authorities having the possibility to take a decision, to adopt a decision, a negative decision. We have to publish and to make available in a series of languages the national legislations that will rule these appeal procedures. So we are working on this. We have started to build the website, the public website that will host this information. You can have already a look to this website, and we have started this enormous work to help the users and to communicate all the rights to the users. We are also using, in some circumstances, artificial intelligence recognition, artificial intelligence for facial recognition, sorry, but in very limited circumstances. First of all, we are using data that we are collecting ourselves. We are not collecting data on Facebook or on any social media. We are collecting data with a guarantee that the data are collected properly. We have a series of provisions obliging for verification of the correspondence between the data and the individuals before recording this data, its data quality, and also the circumstances where we can use this data for facial recognition are clearly established in the regulation. It's not facial recognition in public area like this. It's one-to-one with the possibility to have a verification and to help also the traveler to speed up the border control. And even in some circumstances, maybe it was considered as negative in some circumstances according to the previous panel, but we consider that it's also positive in the sense that it would help the traveler to cross rapidly the border using an automated recognition, facial recognition system. So this is the state of play of what we do. We have no hidden agenda on this. We have nothing in the pipe concerning the use of artificial intelligence. We are fully busy with the implementation of the system. In 2020, we have launched a study, and it's only a study, on the use of the possibility to find opportunities and challenges for the use of artificial intelligence for border control, immigration, and security. The main objective was to identify a set of opportunities. It was a brainstorming exercise. We have up to now, and we have no intention to go forward in this, we've up to now not implemented any of the possibilities that were mentioned. The possibilities were various, like implementing a chatbot to help visa applicants, up to helping border controls and helping border guards with different variations in the way to use artificial intelligence. One of the conclusions of this study is the fact that we should see the use of artificial intelligence anymore as an assistance to a decision and not for a decision. So to help border guards, to help law enforcement officers, to help end users, but not to replace the human being intelligence, which is key for decision making. We also consider that most of the cases that were there, detailed in the study, are not relevant for implementation and would not be useful from our perspective. And just to remind you, it was a study and not a policy paper, so it remains a study, a brainstorming, and nothing. And my last point concerning the Artificial Intelligence Act, because it seems to be that there is some misunderstanding around the meaning of Article 83 and this exception, which is a temporary exception first. And the reason for this is not to avoid that this legislation would apply to EU large-scale information system, but simply because we are in the middle of the implementation. And coming with new requirements would have important consequences on the implementation of the system, would change the timeline, would change the cost, and would probably delay enormously the possibility to start the operation of the system. It's a long, long way to implement this kind of large-scale IT systems. And for this reason, we have this provision to have a temporary exception, just to avoid to be obliged to stop in the middle of the trip, to assess what has to be changed, if anything has to be changed, to ask the contractor to make a new proposal, and to revise the start of the implementation of this. So it's simply for this reason, it's to avoid that we would be in difficulties for implementing regulations that were already adopted by the co-legislators some years ago. I will not go in further details concerning this. I would like just to conclude that the use of artificial intelligence for the implementation of large-scale IT system is effectively an important and challenging topic. And I would like to thank you for having put this topic on the agenda of this conference, because it's useful to discuss it today. Thank you.
Thank you very much, Marc, and also thank you, Niovi and Luca, for these very rich presentations that I hope will give sufficient food for thought and provoke many interesting questions. Before we go there, if I could maybe try to sum up things that for me come out very, very clearly, and that is, first of all, that there seems to be a great deal of consideration being given both in theory but also in practice of implementation to the risks that emerge for individual rights, but also, and to the corresponding safeguards, but also to the opportunities that and the added value that might be provided by the use of technology. At the same time, and this is from the perspective of one of the entities that has been charged with supervision in this context, although with a very relatively limited scope, because this is data protection and in a very specific remit and jointly with national authorities. The complexity of the overall framework is simply daunting, and this is, of course, the technical complexity, but also the legal complexity, where we need to navigate, I believe, around 50, if not more, legal texts at the level of regulations, but also the various implementing and delegated acts. And so this is something that for sure it's probably unprecedented. I could risk the statement in EU law to have this degree of legal as well as technical complexity. And so how to make sure that we really do not lose sight of what is most important in all of that, and that is individual rights and freedoms, is probably the biggest collective challenge that we all have. So before opening the floor to questions from the public, I would like to invite our speakers maybe again to speak to this question of what do you see as the main challenge or risk from the perspective of individual rights, and if you would pick the main safeguard or safeguards that you believe we need or is already in the process of implementation, what would that be? I propose to go in the same order as earlier, so we start with Niovi, please.
Thank you very much for this. I think that what has come from the panelists as one of the most important safeguards is the human on the loop, is how to ensure that AI is indeed assisting decision making and it's not replacing decision making. And I think that one of the main problems that we have about this very important safeguard is that it's very difficult to actually measure the extent to which the decision making by the human on the loop is going to be biased or not. And there has been a lot of studies in that regard talking about automation bias. We need to be reminded that the field of migration is by default a field which has a lot of discriminatory and discretionary decision making, and a lot of bias is underpinning the work, maybe underpinning the lot of the work of border guards or immigration authorities. So the human on the loop is a very good wishful thinking, very important safeguard, and I fully agree with the panelists. But at the same time, there are a series of challenges as to the extent to which there is going to be meaningful involvement by the human. There's not going to be automation bias, or even if there is no automation bias, there may be selective adherence to the instruction by the machine, which means that if the bias of the border guard corresponds to the result by the machine, then it is more likely that the individual will be denied a visa, denied an authorization, denied entry. And I think this is something that needs to be monitored very carefully. It needs to be proper training. I truly value the work of the Fundamental Rights Guidance Boards. I'm not entirely sure the extent to which the work will be binding on the screening board and the extent to which the recommendations that are going to be made are going to be truly taken into account. Also because the screening rules are going to change. And for instance, a member state may decide to change something. And in the meantime, I'm not sure how this is going to work. Will they get approval before the change, or will be ex post? And sometimes this ex post evaluation may take place after an individual or a series of individuals are denied a visa or a travel authorization. So implementation on the ground is really important. These are very important safeguards, but I do think that we need a lot of training, a lot of awareness, and a very good understanding that there are challenges which go beyond privacy data protection. And discrimination is not just direct discrimination, but it's also indirect. And indirect is being protected as well. We know it from Ligue des droits humains, and we need to make sure that there is not even indirect discriminatory treatment of third country nationals. Thank you.
Thank you. Luca, please.
Yes. Now, can you hear me this time? Can you hear me?
Yes, yes.
Yeah,
Please
very
go
good.
ahead. We can.
Good. So I think, very interesting. I feel as agency, our main responsibility is to treat the data that we collect as the most important asset that we have. So we collect a lot of data. Member state entrust us with this data. We collect from travelers, we collect from citizens. So for me, the main issue that I have is how we protect this data, how we protect the data from regular, from cyber attack, but also how we protect them from misuse, how we defend the data protection, how we apply the data protection regulation, how we ensure that the data is protected well. So for that reason, we have put in place within the agency, in coordination with member state and the commission, all possible safeguards that we could think. So on the data protection side, we have mandatory data protection impact assessment. We have audit by EDPS. We have audit by our internal auditor. We have regular checks. And on the cybersecurity side, we have exercise, we have test penetration. So it's vital for me that we protect the data, which are then used by member state, and then we come to the point of the biometric recognition that we just mentioned. But that's the number one assets. In terms of bias, I understand that the argument has been raised many times, but I do believe that the use of the technology will help us to fight bias. So if we know that bias exists in human being able to have this and predict this in the system, it will help us to be more independent in our assessment. So we could use the power of AI to make the assessment even more balanced, more fair. And we also see that we know that in some situation there is a difficult for the matching system to match individuals, and we want to avoid it. So we invest first of all in technology. We want to have the latest possible technology in the matching algorithm, but also we invest in how we train the set. So we are working now with the ISO. I was yesterday at the ISO committee here on creating synthetic image, so that we could use this to recreate all possible type of profile and ensure that when we do the matching is done as accurate as possible without any bias built into the system. So I think if these are our challenge, this is how we intend to address them. Thank you.
Thank you very much. And finally, Marc, please.
Thank you. So we have to be conscious of artificial intelligence and not to accept it like this. Before starting using a tool of artificial intelligence, we should know what it is and we should understand the functioning. It's key for us. we cannot simply take it out of the shelf, implement it, and accept the result of the use of this tool. It's not a black box. It cannot be considered as a black box. It has to be known, and those implementing the tool have to know how it works and what it will deliver as a result first. Second, the data set to be used for the training of this tool should be our, not one developed for another purpose, not one developed in another area of the world, because it would contain bias probably, it would not correspond to our standards. We have to know which data are used for training the tools. So knowing the tool, knowing what the tool is doing, or it's done, not a black box, knowing how to train the tool with our data sets and not external ones, and finally, implementing a constant monitoring of the outcome of this tool, because it could be biased, but it's our task also to monitor this risk and to ensure that if there is something which is not acceptable or which we could not consider normal, we can correct it. So it's also the way we are using any information system. It should be transparent. The use of the system of this kind of tool should be transparent and should be known. And finally, as said, the decision is not the machine taking the decision. It's a human being taking the decision. So with these are the conditions we see as in the way to use these tools. And probably it's essential in the way we're implementing the systems. Thank you.
Thank you very much to all three speakers. And with this, I would like to open the floor to questions. 1, 2, 3. The 3 questions, please.
Thank you for this presentation. I have a question concerning the principle of data quality. So the principle of data quality, as a reminder, concerns the lawfulness of the data and the accuracy of the data. I would like to ask this question to actually all the speakers. Do you believe there's a shared responsibility between a member state, the lawfulness of entry bans in the Schengen information system and the principle of data quality? I would also like to take the example of Hungary, which has been recording entry bans in the Schengen information system. And, well, we all know that there's been several rulings concerning Hungary by the European Court of Justice, concerning the asylum system and the law enforcement system. Does that mean that the data recorded by Hungary in the Schengen information system are not abiding with the principle of data quality? Should that mean that EULISA take action, or the EDPS, the working group on artificial intelligence, because there is one project concerning the automated siren report completion, and I would like to ask if the Commission and EULISA believe this automated siren report completion is in compliance with the jurisprudence of the European Court of Justice on individualized and proportional filing of alert. Thank you.
Sorry, dear Chair, just to say that we still have 7 minutes for the questions and the answers.
Thank you. And I would ask our, please be very brief.
Yes, thank you very much.
Thank you.
My name is Alexandra Karaescu. I am a PhD researcher at the European University Institute, and I am looking exactly into the use of AI and digital technologies for migration management at EU level. I have a very technical question and very short question for Mr. Luca Tagliaretti. Excuse me for mispronouncing your name. You mentioned, if I understood you correctly, that AI will be used as part of the ETIAS profiling process. And I would like to know to what extent it will be part of the profiling algorithm that is envisaged under the ETIAS regulation, or under the Common Repository for Reporting and Statistics, which is envisaged under the interoperability framework, or both? And a very short question for Mr. Marc Sulon. And we heard earlier Professor Vavoula telling us that AI systems has component parts of large-scale IT systems were excluded from the scope of the Commission proposal for an AI Act. And I would like to ask you if you could comment on the rationale behind this exclusion, because there has been a lot of controversy and a lot of scholars trying to understand what was the reason behind it. And a short comment on how the recent revision in the latest text adopted by the European Parliament, if it makes it to the final regulation, will affect your work. Thank you very much.
Thank you. If I may, there was one more question, but please try to be very brief. Thank you.
Yes, I will be brief. My name is Joseph Quimber. I'm from Luxembourg. I'm not really an IT person, but very interested in the possibilities that the AI can bring us. And we see, especially in Europe, sometimes AI development being hindered due to the positive but also challenging GDPR regulation, and also in the view of the new AI Act. So my question is, knowing that the availability of large sets of data is at the core of the technology, my question is mainly targeted to Mr. Tagliaretti. Do you see opportunities being not realizable because of the regulations that in place, that you may regret not being able to implement them and to realize them? Also, in view of the study that was mentioned with this sort of SWOT analysis, so with an opportunities and weaknesses analysis. Thank you.
So please, who would like to go first? Luca, you've been mentioned.
Sure. I'll cover my part and then
Please
I'll leave Marc.
Be brief. We need to.
Yeah, absolutely. I'll be very telegraphic. So on the question on the use of AI in the screening mechanism of ETIAS, Marc explained it well during his presentation. The regulations say the regulation talk about an algorithm. The algorithm is matching the ETIAS application with indicators of risk. For example, if you come from an area which is there is an epidemic risk, so there is not a screening mechanism using AI, is using a very simple algorithm. So there is no artificial intelligence behind that selection. On the question on the opportunity miss, we do not see at the moment the impact. So for us, at the moment, everything that we have as a regulation allow us to develop our system and do the matching that we need to do in a proper way. So we also can use artificial intelligence in management of our systems, in cybersecurity, in document checks. This was mentioned before. So at the moment, we don't see a limitation for us. We see how the technology develop if there is an impact in the future. And the last question was on the data quality. Okay, we on this point we are in a way abiding the regulation, and we abide what we receive from legislator. So it's not for us to decide whether the entry from one country or another are illegal. It's something that need to be given to us by the legislator or by whoever is doing this monitoring. If this is the case, we will act, of course, accordingly, but we cannot make decision on ourselves on what's legal or not. That's my answer.
Thank you. Marc?
Yes, thank you for these questions. Concerning the Artificial Intelligence Act, I think that I covered the point, but maybe I was not clear enough. This exception is temporary, and the objective is to give us the possibility to continue working with the implementation of the systems without being in the expectation of what will be the decision and the consequences of this act on the implementation of the system, which could lead to delays or need to change or uncertainty on what we can implement, and could increase the cost and really delay the implementation. The Parliament is proposing a delay of validity of this provision for 4 years. Not certain that it would be sufficient. We have a lot of things in production, in implementation for the time being, and probably the reference to a major change or to a change of the legislation. And we have probably also to clarify this. It's the best way to do it, because it's also giving some certainty for each system and the possibility to plan also in a new version what has to be changed immediately in the regulation. Concerning the data quality, it's a complex matter. You know that it's also, the system is also based on trust between member states. Member states are responsible for the information that they are loading into the system. Commission has no access to this information as ELISA does. We cannot see what we have, what was recorded into the system, and it's up to member state to be compliant with the provisions of the regulation.
Thank you. And last but not least, Niovi.
Yes, thank you so much. On your query, I think that we are a little bit doomed on that matter, because it's only EULISA cannot check the data in the automated checks. They don't have really access to the data, or so they claim. But also, supervision hasn't panned out, and to the best of my knowledge, the Schengen evaluation monitoring mechanism, I'm really sorry, but a lot of the things are not publicly available. But in the previous round, we know that there were problems with the specific alerts on discrete checks by France, and I've checked a lot. I've never seen that picked up. So I doubt that other problems, such as the one that you mentioned, may be picked up. Maybe or maybe not, depends on the member states and the evaluation mechanism. So that will reply that. I think I'm not going to say anything else, because we are done. On the AI Act, I think that if there is to be temporary, it needs to be explicitly temporary, because if we have to bring within the scope when there is a significant change, first of all, it assumes that there will be a change in the systems, even though we know that there is still a study and therefore nothing has been planned. So if there is a plan, that means there is going to be a significant change. And if this is to be temporary, it needs to be explicit in the legislation. Thank you very much.
Thank you very much, and thank you for your patience.
Okay, thank you very much. Good afternoon, everybody. My name is Jean-Louis de Brouwer. I'm the director of the European Affairs program of the Egmont Institute. I'm quite reassured to be sitting next to Henrik Nielsen, because both of us are supposed to draw the conclusion of a conference that he just joined and that I did attend only this morning. So bear with us. I will start, as we are again under time pressure, I will start by the end. That's to say, by thanking very warmly Fabian Lutz and Philippe de Bruyker for having put together such a fantastic program for this conference, as well as thanking all the speakers, those I listened to this morning and those I was not able to listen to yesterday. Thank you very much. This gave us also the opportunity, Philippe, to meet a series of old friends, which is quite enjoyable. But by the way, listening to the last panel, I all of a sudden realized that maybe someone was missing, and that's Dragos Tudorache, your predecessor, Marc, who is one of the co-rapporteurs for the AI Act, who was a former head of unit in DG Home and who was quite instrumental in developing the VIS and the SIS2 to be borne in mind for the next discussion about this subject matter. What did I do and what did prevent me to attend yesterday's session? I was invited to attend a closed-door workshop organized by a German foundation, I will not name it, about, guess what, the future of the EU migration policy. So we were a bunch of political scientists, not that many lawyers, discussing about 2 days. And very quickly, the main topic of the discussion was the tension between Schengen and the future of the European asylum system, which completely overshadowed these 2 days' discussion. And well, in my hotel room on Monday evening, watching a movie on the television, yes, I'm a human being too, so I'm watching a movie on the television, I all of a sudden thought about an alternative title for this conference, Philippe, which could have been Saving Private Schengen. But okay, that's something that will still be hanging in front of us. We might have the beginning of an answer for those of you who are going to attend it, because you might know that we have at 1:15 in the Egmont meeting room a briefing by Fabienne Keller about the state of play concerning the ongoing negotiation concerning the future of the Migration Pact. But I would leave it like that and now leave the floor to you, Anna, please.
Thank you very much, Jean-Louis, for that kind introduction. And from my side, certainly a pleasure and an honor to be part of this conference. It's a bit of a triple challenge to, one, summarize everything Schengen, a challenge in itself. Challenge two, to come after such a wide range of prominent speakers who all know much better than me. And thirdly, to do it all in 10 minutes. But well, I'll give it a go to see what I can do. I would say the basis for what I will say is what you are certainly well aware of, the Commission State of the Schengen report that was presented on the 16th of May. I will not touch too much on the background because I know you have reviewed that in depth, the fascinating history of Schengen and Schengen as an experiment. Perhaps nevertheless to flag one point that is very close to me, that indeed it is an experiment from the point of view of cooperation between states, in point of view of the treaty, the point of view of the legislation, but it's above all an experiment and a successful experiment in creating the biggest travel area in the world without borders and which benefits both EU citizens and third country nationals. And the experiment is still there, which is amazing. Now, how do we keep it? How do we preserve Schengen, which I think is a shared goal of all of us in here? Well, in a sense, to oversimplify, of course, but nevertheless to say it all starts at the external borders. Schengen will not survive unless we ensure a high level of border protection and where the management of the external borders is done in full compliance with fundamental rights. That is the absolute basis. And that's why such a strong emphasis is put on that in the Commission's report that, as mentioned, came out mid-May. I don't have time to dwell on that in more detail, but I will just flag also the previous communication from the Commission in the spring on setting up the European Integrated Border Management System, which in its process and its somewhat laboriousness might come across as somewhat bureaucratic, but which is truly a step forward, a big step forward in having truly a European strategy in terms of how we deal with our external borders. Now, if it starts at the external borders, you could say it ends at the internal borders. So how do we ensure that we keep them open? And there, for sure, we have challenges, which I know that you have reviewed. Allow me just to zoom out a little bit on the full picture, and without being able to back this up with concrete data. Nevertheless, it remains a fact that the absolutely overwhelming majority of all travel in Europe across internal borders happens without any checks or any controls whatsoever. So Schengen is still there. Again, we have challenges and we are working on them. I would perhaps stress that it's also a triple challenge, not only a legal one, but also a political one. This goes to the absolute highest level in a number of member states, i.e. what to do at the internal borders. And thirdly, also the operational side. We need to get better in getting member states to work together at both sides of the internal borders, and where often police checks can be more effective in terms of what they want to achieve and less intrusive on the travel flows than the formal reintroduction of internal border controls. The third area to touch briefly on, also from the report, you will have seen perhaps a bigger emphasis than in the past on elements related to the fight against organized crime. Now, in this audience, I wouldn't even dare to say one word about what part of that is Schengen relevant and what is not Schengen relevant and why. I leave that to the experts. But I think the bottom line is important to emphasize. That is also part of preserving Schengen. We need to be successful in how we fight organized crime, and notably, perhaps one of the biggest challenges for the moment, drugs trafficking, if we want to preserve Schengen. That must be part of it. And that must be part of, let's say, our program. Now, beyond that, and trying to look a little bit bigger, you could say, in a way, Schengen is not an island. That goes, first of all, policy-wise. So as Jean-Louis touched upon already, the link between Schengen and the development of our migration and asylum policies. Again, to be brief, I will keep it very simple. The more we can move towards common migration and asylum policies in Europe, the stronger Schengen will be. And the more we will be successful in keeping it. And hence the importance that we make progress on the pact and that we wrap it up before the end of this legislature. Second point, perhaps less easily seen, but in my view, equally important, if not more. Schengen is not an island geopolitically. It matters a lot to Schengen what happens in our neighborhood. And unfortunately, as we all know, many bad things have happened over the last 10 years with wars in Syria, in Ukraine, the breakdown of law and order in Syria, instability in a large number of other countries in our neighborhood. This makes simply Schengen more difficult to manage. This we must acknowledge. And it requires us to constantly adapt and to use all policy tools we have to deal with the impact of that. That stretches all the way from, let's say, core Schengen policies such as our visa policy, but across a range of other fields, leading us all the way to the EU external policy, which is also relevant for preserving Schengen in terms of how we interact and work together with our neighborhood the best we can and try to mitigate the impact of conflicts and in crises in our neighboring countries. In that sense, one can say, and I think it's fair to say that as a result, it is more challenging to manage Schengen today than it was 10 years ago. But once again, it is still there. So we have managed to meet these challenges nevertheless. Where we try to bring it all together is in the new cycle on Schengen governance that I know you have also discussed, which I think is very important also for the future of Schengen. There needs to be a space, a regular space where member states and institutions can discuss at political level what are the challenges we are facing, how are we dealing with current problems. We need to develop more our capacity for foresight, for awareness, for forecasting, to be able to anticipate challenges as much as we can, bearing in mind that predicting the future is usually not such a good idea, as COVID told us, but still, as much as we can, we need to bring that into our political discussions. It will also provide a space to discuss who does what, because again, leaving aside the complexity of the variable geometry, Schengen is and will remain an area of shared competence between the EU and its member states. And that leads to the question, so who should do what? Who is responsible for what? And it's important and that we will use the Schengen governance cycle for that to review, well, is everybody doing their part? Who is lagging behind? And that goes for both policy development and above all implementation for the institutions as well as for the member states. So that was a quick review of what I would see as the perhaps state of play for the moment where we go. I say it not just because it's my job, but because I actually really believe in it. Although the challenges are bigger today than they were 10 years ago, I think also there is more Europe in Schengen today than there were 10 years ago. And that gives us faith for the future that we will be successful in preserving Schengen. And the exchanges that you have in conferences like this are very valuable to help us to do that, to understand the challenges and then to see everyone's point of view. Thank you.
Q&A. Well, usually you congratulate this kind of speaker because he kept to the time limits, but I think that you said a lot of very essential things in a few minutes. We all heard what you said. I mean, there's a way, but there must be a will also to go until the end of the way. There will be soon debate ongoing about a possible future enlargement on the Union, which will also bear consequences of not only the whole migration agenda, but on Schengen in particular. So I would not say the jury is out, but we are not completely there yet. And for that will remain a challenge for the next Commission, whether there is a pact or not in the meanwhile. It will be more difficult if there is no pact. You're absolutely right. I mean, if the jury is still out also on the pact, then it will be very difficult to square that circle. So let's hope for the best. Thank you very much for all of you to have attended these 1 day and a half conference. There will be a book soon, Philippe, about the outcome of the conference. Maybe we could have a book launch event together so that there could be continuity about this. For those of you who are traveling back home, I wish you all a safe trip back home, probably crossing Schengen land and escaping any kind of control at the internal border, hopefully. And for the other ones, enjoy Brussels as long as you can. Our roads will cross again in a not so distant future, amongst others, thanks to the ongoing, untiring activity of the Odysseus network and of its coordinator. See you soon. Good afternoon. Bye-bye.
And I think it's something that we need to be proud of.